Good morning. Are you Brandon Henderson? And will your client waive the formal reading of the motion?
Here we go.
Mr. Henderson, in cause number 22-40931, I have a motion to revoke your community supervision. Shows that you were placed on probation June 13th of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges you violated your probation. Count 1 alleges that you committed the new offense of aggravated assault February 26th of 2025 in Montgomery County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of unlawful carrying a weapon in Montgomery County on February 26, 2025. And is that true or not true?
True.
Count 3 alleges that you did not provide verification of performing the community service hours as required. And is that true or not true?
No, that's not true. I did
Okay.
most of my community service for
Okay,
myself.
that's fine. Count 4 alleges that you are behind in your court-assessed fees. And is that true or not true?
True.
Count 5 alleges that you failed to remain in the state of Louisiana and that you were in Montgomery County on February 26, 2025 without permission.
True.
Count 6 alleges that you failed to report to the Jefferson County Probation Department by mail-in or online for the months of October, November, and December of 2024, and then January and February of 2025. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 4, 5, and 6 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
State,
Just so the court
Yes.
is aware, he received 2 years on the case in Montgomery County. That has been disposed of according to their office.
okay, thank you. State tenders number 1,
No objection.
it's admitted any evidence that Mr. Henderson's not competent.
Thank you, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your plea of true to those counts freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find counts 1, 2, 4, 5, and 6 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That sentence will run concurrently or at the same time as your Montgomery County cases. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. All right, you're Kaylin Salzar. And Ms. Salzar is on probation in cause number 24, DCCR 2234, and that is for a misdemeanor offense or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court-assessed fees, that she admitted to using alcohol in violation of her probation, August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kemmler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the 2 cases before you, she has 2 separate
DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from, is what's listed in the motion. It looks like the only thing holding her is the bond on this case. And if she's, in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask that be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. If she does have the interlock, I don't think she needs to drive at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just going to put off. And so obviously, if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without
Right.
it being approved by probation and ultimately by me, and so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
That's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines, Your Honor.
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. Do you understand? Any other conditions that?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
And keep in touch with your bondsman.
You can go back, yep. All right, you are Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously. Entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have Mr. Hutchins here for.
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address.
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
So, Deacon?
I would ask him a few questions if the state's not going to call him.
So I'll get you a little bit.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st of 2020.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. Then July 21st, he did not show.
That's what it's,
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300,
Okay,
which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
okay, thank you. Mr. Kimler?
shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, you're correct.
So he would have 169 hours in each of the three cases
Yes.
credited, is that right?
Yes.
And is that so even though he was already on probation on one and then we gave him probation on two after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service.
Yes. Sorry.
May I proceed, John?
Yeah.
How long have you supervised him, Mr. Patton?
So I'm a supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
Because you have some familiarity with him.
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he be continuing on probation, he would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause you to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexander Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
But she was the one that was, I guess, directly supervising.
That is correct, yes, sir.
You have access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or...
Not that I've come across, no, sir.
That's what it is.
No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you had been on probation since you were 18 and you
This
just
is the
couldn't.
turning point of the hearing. Up to now, the defense has focused heavily on mental health struggles, depression, PTSD, employment history, and the argument that continued treatment could help Mr. Petty succeed on probation. But the prosecution is now challenging not only his compliance record, but also his credibility and willingness to follow rules when given opportunities. Legally, probation revocation hearings often center on whether the court believes rehabilitation remains realistic. The judge has already heard testimony about missed drug screenings, incomplete requirements, and previous recommendations for treatment that were not followed. That creates a difficult position for the defense. Here's the
18
question.
and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's going to make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, for from everything that's going on in the past, with me being shot and stuff like that. I was shot in my neck and my arm, so since then I've been having real bad PTSD, real bad depression, bipolarness. So, there's some days where I'm good, some days I'm not. Some days I wake up on the wrong side of the bed from having nightmares, and some days I'm just as happy as I can be. So from that point on, at this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and, aggravated robberies and all that. It's just a bad environment for me, and it puts me in a bad mood, puts me, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MHMR, but I never went just because I felt like it was I felt kind of low, of thinking I would go to MHMR, because
Stigmatized.
yes sir. So at this point, I don't want to go to jail or prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. I never, just because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and that kind of behavior.
I could ask him a few questions, John.
Sure. Wait,
I'm sorry.
best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday, 11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that for my ex-girlfriend, being dumb at the time.
No gang affiliation.
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant?
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
I always held a job. Even if it's working at Whataburger.
What was your last job?
Shipley's Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out? You a carpenter?
Yes, sir.
Scaffold builder? What were you?
We were doing woodwork, building decks and
Okay.
carports and lunch tents and that action.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you had returned fire?
Yes, sir.
That's not what,
I understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it, and I'm not trying
my
to.
understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot, you went there to go shoot Christy, but, which is your child's mother, right? That's not true? No? So did you mean to go shoot the two girls that got shot, Alexis and Taylor?
No, man.
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes, the two girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were gonna rob him. And in the course of that, there was a gunfight, but he wasn't going there to shoot anybody.
All right, well, that's,
He was
again,
going there for an illegal purpose.
that goes against everything that was said and everything that he agreed to back then, because,
That's correct, Judge. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and/or Taylor might
Sure.
have been killed, but he was there to go kill Christie.
I didn't represent him in
okay.
that, so I don't
All
know.
right. Anything else? All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safe P now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing
The court's
what
decision is now final. After reviewing the testimony, probation history, violations, and argument from both sides, the judge concluded that continued supervision was no longer appropriate. The court found sufficient evidence to revoke probation and impose prison sentences of 7 years on the prohibited weapon case and 12 years on each aggravated assault causing serious bodily injury case, with all sentences running concurrently. Throughout the hearing, the judge repeatedly emphasized a central theme: opportunities.
or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact, and you can't claim that, well, I feel bad because I got shot by somebody who was defending two other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address the, always with these jail incident reports without